Yes, we are here now for the next presenter. We request Mr. Dinesh Jotwani ji, if you can hear me, sir, we'll have your thumbs up and affirmation. Yes, sir, we can see you. Thank you very much for joining, sir. It took time, but as learners of you and people who aspire to know things from you, we have been able to keep hold of the time with you. Thank you very much, sir, for joining. We have our students and presenters all over the world who have joined us. The session is also live on YouTube as well through Amity University. The students here at Amity University Tashkent, they wish to welcome you, and I'm introducing you to them so that we can move on to the keynote address from your side, sir, in the IPRs second day of the conference. Yes, everyone, we are moving ahead from robotics to smarter cities, cloud computing, something about maths, to something very general, very important, and very specific. I mean, you can keep on making some research and patents and everything, but how that thing will become yours? I mean, there should be your identity going in with the product if it goes to the market. Anyone should not be able to do it. So the best one we have with us means if you keep on searching for things, who knows how to keep your intellectual property yours and manage it smartly, ethically, as well as for a long term so that you can also guide others. We have the presence to deliver keynote on artificial intelligence and its implication in the field of intellectual property rights by Mr. Dinesh Jotwani ji. He's Head Government Relations, NCR Corporation, India. We welcome you, sir, with a round of applause from the attendees. You have more than 30 years of experience, long, I would say 3 decades of experience, and each day must have been new to you in terms of experience of deep understanding of policy, law, technology, litigation, and government relations. Especially you have worked on software, trade, IPRs, internet law, and cybercrime, cyber safety, which is also some concern for all of us. Now, your career highlights, we would say you have been a counsel to some big firms in terms of business and corporate. FICCI has been one, NBAI has been one, which is the Indian Legal Foundation, to name a few. You have also been associated with Delhi University. You have your honors in economics from Delhi University, moving into IPRs, talking about artificial intelligence. I would say that makes it a successful day at the conference. To invite you, I would request everyone again to put your hands together and invite Mr. Dinesh Jotwani to deliver the keynote address. So,
thank you so much, sir. Thank you. Can you hear me well, all of you?
Yes, sir. Yes, sir. All clear.
Excellent. Thank you again for the warm introduction. Thank you to Amity, faculty, management, and of course, students who are gathered today. I'm going to talk about intellectual property rights. That's what I've been doing from last 20 years. But today, I'm going to advance a little bit from intellectual property rights. I'm going to talk about artificial intelligence and how it is impacting intellectual property rights of individuals, corporations, and also machines, robotics. I was given to understand 10 minutes. I'll try to confine myself in 10 to 12 minutes of my presentation, give you the basic ideas, because the law is still not settled. So what my presentation will constitute is more questions, food for thought for everyone, and it should give you more questions, because still I think the world is exploring the answers. The consensus over artificial intelligence and consensus over intellectual properties arising from artificial intelligence is not settled. It's not settled in the advanced countries also. It's not settled in the developing countries also. Let me go through. I have few slides only, 5 to 6 slides that I will talk about, and then we can move on to question answers if we have any. Let me try to share my slides.
Please, sir. Yes, so we can see the screen and the slides as well.
Okay. Is it the full screen? Let me see if you can see. Can you
Now
see
it
the
is the yes, sir, full screen. Sir.
All right, great. Oops, no, this is something else. This was my yesterday's slides. One moment, let me.
No problem, sir.
Sorry, it's taking time. I thought I was ready with it already. One moment.
Best.
Can you see the slides, please?
Yes, sir. Yes, sir. We can see it, sir. Amity University 1011. Yes, sir.
All right.
Thank
Okay.
you.
Thank you. So I'll jump into the slides now and give you a context of what I'm trying to say, how we are linking artificial intelligence and IPRs. And thanks for a nice introduction you already gave. So I'm Dinesh Jotwani. I'm a patent attorney and an IPR attorney. Work for companies like Microsoft, Cisco, Dassault Systems. We also I have a law firm, and we take care of all aspects of IPR, which is from creation, protection, enforcement, prosecution, all aspects of IPRs that we take care of. Okay, so I won't go into what constitutes patents, copyrights, industrial design, and trade secrets, different kind of IPRs, because I'm presuming everyone already knows about it. And I'm moving a step further to talk about intersection between IPRs and AIs. I hope that is okay. I'm presuming, and if there are questions, of course, we can take it at the end. But basically, we all know artificial intelligence is generally a part of computer science, and it is trying to take over more and more tasks which are done by human and human intelligence. So there are statistics where it says that more than 50%, 60% of the jobs will go, and people need to upgrade themselves each time. Otherwise, they won't be able to survive in the new economy as artificial intelligence and takes over human workloads. Recently, the AI have really matured, and almost all the tasks, except I'm glad to say tasks like doctors and lawyers, which won't be taken over so easily. In legal field also, AI is trying to automate the contracts, patent application, trademark application, all those things. But given the kind of complexity some of the professions have, where AI will not be initially denting, but most of the jobs will now require how you run a robo, how you run the machines which do the AI work. Keeping that in mind, so what is happening right now, the AI generating so much of work and doing so much of the work at the background. Some of the examples which I would like to share, how artificial intelligence has generated intellectual property rights. We talked about different kinds of intellectual property rights in form of patent, trademark, copyrights. But these kind of works will be taken over when the artificial intelligence generates them.
Sir, there's a small.
Yeah, sure.
Yes, sir. Sir, like copyrights, basically we all see that C on a circle. But if IPR can be briefed by you, because we also have students who have come from their school and they're doing a foundation course with us here. So they'll be moving to different streams next year. So if you can explain like briefly what IPR is in simple terms so that they also understand it in a better way.
Okay, absolutely. I can do that very, very quickly. So intellectual, I'll tell you the basics. I was presuming I'll talk about little advanced in terms of IPRs and artificial intelligence. But yes, I can quickly explain what intellectual property rights are. IPRs, intellectual property rights, are the creation of mind. Whatever you create by way of your mind are IPRs, and they are protected by different acts or legislation that country has. Um, it can be of several form, what your mind creates. Of course, so this is something what we call intangible. Intangible is, uh, which you cannot touch or feel. That will be called intangible. Uh, ta- uh, so IPRs would something that you might write a book, or you might create an invention, you might create a new design. All these different forms get protected by different legislation. So there is a Patent Act, Copyright Act, Design Act. I'm talking about India now. Fortunately for IPRs, because of the presence of World Intellectual Property Rights Organization, WIPO, I will say 90 to 95% of the IPRs are the way we protect and enforce is common globally. WIPO is very active in trying to make it uniform across the globe. So whether it's patents, trademark, copyrights, or designs, it will be, I mean, the chances that what Uzbekistan will be in India, same will be in US, and same will be in Pakistan. So there's great chance. So when you study IPRs, and I encourage a lot of engineering students to do that, what you do is actually you're working at the global stage. You're working for the global clients. You're working for the global agencies and authorities. So it's absolutely give you a good exposure. Patents are, as I said, I'll again briefly take you through. Patents are inventions. Any incremental small inventions are protected by patents. And again, you might have seen written on some of the product patent pending. So there is a symbol patent pending. Same with copyrights. You see at the bottom of my slides is copyright written. So this is what the symbol is of copyrights. Then designs also, many countries it gets protected by way of a patent legislation. Trade secrets, of course, in countries like India, there is no legislation, so you don't have a symbol for that. There are different protection durations for each of them, like patents would be protected for normally 20 years. Copyrights is in India, they would be from the death of the author plus 60 years. So copyrights like books and all, books, movies, songs, software code, all gets protected by copyrights. You file for registration of copyright, which is an easy process. Creating a copyright is difficult. Writing a paper is difficult, but filing for a copyright is easy. Industrial design, same. They get protected for 10 years plus 5 years more. And trade secrets are forever. We know trade secrets in Coke and McDonald's. They are forever. From last centuries, they have protected because they have not revealed it outside. So that's a basic overview of IPRs. I hope that helps a little bit in understanding today's
Yes, sir.
topic.
Yes, sir. Yes, sir. Yes,
Yeah,
yes,
yeah.
thank you.
And any questions, we can take it now or subsequently, not a problem. Okay,
We'll
so
have it once you conclude, sir. Like
sorry.
we'll have the questions at the end. That would be better. We'll compile them and we'll share.
Absolutely, that will be great. All right. So today, I think everybody the conference, being we talked about artificial intelligence at great length. So everybody knows about that. That basics, I think, would be clear, and it has two parts, as we said. A sub part of it, which can be deep machine learning and deep learning. There's a difference between both of them, and all different form of artificial intelligence is somehow impacting IPRs also, and we'll go into that. how, because artificial intelligence nowadays generate creativity also. You can do a lot of creative work using artificial intelligence, and henceforth the patent, trademark, copyrights, trade secrets, which were protected, and there was a presumption that there is a human being that is creating all that. But now machines are creating this kind of an artificial intelligence. So some examples which we can internationally we can give is paintings being done by use of artificial intelligence, a portrait being created. Earlier, the human beings would do that and we would copyright, lawyers would copyright that. There are computer programs that creates music, compose music. So earlier, human beings or companies would compose music, and lawyers would protect them. So now there is a whole paradigm shift where we have computer programs doing all this. There is not a day far off where novels will be written by artificial intelligence programs. In my firm, I actually tell people to write an article. So what I'm afraid of that, they don't use a program which they copy an article and they use a program that changes its tone, it changes its written style, and they submit it. So that's another. But again, just to avoid plagiarism, the computer programs make sure that the language is different, and the sense comes out to be the same. So again, the day won't be far off when articles and novels will be written by artificial intelligence. There's not, and then about the data, there is a whole lot of data. Earlier, the data that used to be generated would be protected by way of databases, by way of copyrights. Again, now the social media is generating lot of data. We know about human beings. We know their behavior, we know their marketing habits, we know their political likings, we know their spending habits, how they like to spend. So everything comes in the form of a data, which would be further processed using artificial intelligence. So artificial generated output can do inventions also. In fact, there have been 2 patent applications filed, which is actually being generated by the robos, the artificial intelligence program, which is one is a beverage container based on the fractal geometry. And then there is also a device for attracting enhanced attention. Possibly, you can use it for search and rescue operation. So there have been patent applications that have been generated by use of artificial intelligence. All right, let me go on and talk about some of the issues. In 2019, WIPO did an international conference and looked at what happens when the artificial intelligence creates this kind of a creativity, which was earlier protected by human beings and companies and organizations and institutes and universities, now being done by a computer program. So some of the issues, and I'll be pretty fast on this because of the time constraint that we have. But some of the challenges that the WIPO conference discussed was who will be the inventor. Suppose there is a patent application we talked about in the last slide, patents being filed, which are inventions or not of human beings, but of a computer program. So who is going to be the inventor and who is going to be the owner of it? What are the disclosure requirements? Every patent application asks you, how did you make this invention? How, one is the end product, but how did you make it? You have to disclose it. Will computer program and artificial intelligence have such kind of data where they'll be able to, disclose? In fact, they won't be able to disclose how they arrived at the end product. Who owns the invention? That's a big question. And there can be 3 people who own it. One is a human being. The other is the artificial intelligence computer program that owns the invention or patent. And third can be combination of both of them. If it is a combination, then what is a part of it? How much credit has to be given to humans and how much credit has to be given to machine? Lastly, they talked about what is an inventive step, right? What exactly is an incremental part? Now, if humans create something, they can easily say, okay, we mix these pharmaceutical products together, and this is what the inventive step is. We have this pressure, and we have this. heat that generated a new molecule. But now here is an artificial intelligence creating that molecule. How did they do it? What is an inventive step? If computer program can think of it, there is a concept called obviousness. So it's very obvious, in the patent examiner will have much more discretion in rejecting and saying that there is no inventive step in it. So these are some of the issues which with respect to patents that were discussed. Copyrights, of course, as I mentioned, all copyrights so far are created by human beings, by author. The music is, the songs are written by lyrics. It's composed by human beings. So who is the original author if music is composed by a computer program? How will it get licensed? We see that music gets licensed. So will a machine license it, or will a human being license it? So there's a paradigm shift now. How do you do a licensing agreement when an artificial computer program creates that kind of a music? What happens to the issue of deep fakes? Now, deep fakes, we know, we can see politicians across the world, there are fakes, and it looks like they're speaking something which they have never spoken, but the kind of movement, the facial movement it has, it looks like they are giving that kind of a speech which they never gave. So deep fakes, who owns those deep fakes? The person who created the deep fakes owns it, or the computer program, which is artificial intelligence machine, that owns it, or it is owned by the person whose deep fake is being done. So again, I'll boil down to the fact that the ownership issues will remain a big challenge in copyrights also. And again, it's not settled. The law is not yet settled, and across the globe, the deliberations are going on. And this is what the artificial intelligence will disrupt the legal IPR markets and how the companies do business. Again, in case of designs, who own the designs created by, today we see even a software like SolidWorks where you do designing, or CATIA where you do simulations. The inputs are given by these kind of software, that why don't you design it in this manner and that manner. And again, there is an element of artificial intelligence in these designing software also, which suggests you that how you could probably design a new product or design a new new kind of a packaging, I can say. There's a lot of packaging business that goes on where the designing takes place and use of artificial intelligence can take place. So who is the owner of that? Is that a machine or the software that is suggesting, which is probably a different module in the current designing software that exists? And who owns the liability of this? Suppose there is a mishap that happens. Somebody designed something, an aircraft which had a poor design. So who owns it? Is the fault of an artificial intelligence machine who suggested a new design of the car or the aircraft? Or is it the human being who actually approved it, or it is the company that does it? So the question of liability when an artificial intelligence creates and suggests inputs to human beings to design for a product is again, in the realm is something that still is being debated across the world. So these are again, I'll go to, this is perhaps my last slide. Trademarks, again, we see a lot of machines which suggest logos or slogans. So trademark is a logo or a slogan, which is actually visually, which can be seen or felt. Different tunes can also be trademark. Different packaging can also be trademark. So all these things are very easily being done by artificial intelligence, replacing the human beings. What happens in a case of infringement? Suppose somebody copies it. I design a trademark which is actually being created by a machine. So who will file an infringement case? Will the company who owns the trademark, or so currently we have something called an assignment that needs to be done in case of a trademark when it gets created by a consultant or an employee of a company. So who will give an assignment in that case? So these are some of the typical issues where the world is debating, and I'm hoping that as the statistics were given, which says 40-50% of the jobs will change as with the artificial intelligence. So how we are going to change, and I'm sure there will be different global rules with respect to artificial intelligence. Trade secrets, again, we talked about personal and non-personal data, which all the social media knows. In fact, what happens if the Facebook data, and Facebook data, anonymous data, it knows much more about me than my family members also. So what happens if Facebook leaks that data, or it get breached? It will easily blame that a module in an artificial intelligence that was created resulted in a breach. So what happens to data privacy and data protection liability, whether it's personal data or non-personal? There is a huge amount of non-personal data also that these companies hold. So the trade secret law, which India does not have, unfortunately, and needs also kind of a revision, and we will see a lot of legislations happening, a lot of rules being created, and this is where I think the engineers and lawyers need to sit together and work on a policy framework. Big and policy, there are going to be a policy issues. So will there be a separate entity for artificial intelligence? We all know legal entities. We can have companies, LLPs, trusts, societies, all these legal entities have been created. But what about inventions and products and designs being created by artificial intelligence? Do we have a separate kind of a law for them, that this is being created by use of 90% of the artificial intelligence? Do we have a separate protection administration for them? These are some of the big issues, and I did read the outcome paper of WIPO in 2019. These are, again, big questions, which I leave you with right now. And these are food for thought, but of course, this is my last slide. And I would say the world is, of course, we're living in a very interesting world. And we will surely be seeing a lot of changes on how we do business, how the technology runs, and how global legal laws would come in prevail, which every country would have to follow.
Thank you.
Thank you.
Thank you, sir. Thank you very much.
All right. Any questions? I'll be very happy to take it now.
Yes, there are questions. I was also listening, like a student was making notes. They were also listening. But we would say one thing. Yes, question. Yes, you will be asking. So we have one student going to ask a question. You can come here if you want to, please. Come here. You come here on the desktop of Dr. Seema. You'll be visible. Yeah, you tell your name and then tell.
Good afternoon, Mr. Dinesh. So I have interested about one thing. So for example, I'm an inventor. I have created the program with artificial intelligence which create music, for example. And this program became popular and everyone is using this. But in someone's phone, it create really like good music and it become popular. So whose music is this? Is it mine one or the program which created in the phone of in his phone? So it's the music of the user or mine one? So
good question.
Yeah, actually, yeah, very important question. Who? So if I understand it, who will? So if there is a problem and you find a solution to it, and you use artificial intelligence in actually finding a solution, and it becomes very popular over different audience, and people want to use it, business want to use it. So who actually owns it? So from traditional laws, I would say, see the person who gave you the problem is not the owner of IPR, has never been an owner of IPR, because he just told you what. The person who actually gave a solution is the person who actually is the owner of IPR. And of course, now the bigger challenge is now there's an artificial intelligence which analyzes the problem, gives its own solution, and it becomes very popular. So we are not sure, because now there is a very important element of the person who is giving you this is what the challenge is and the problem in the technology is, and there's an AI which is solving it, and the AI has been created by you. So all three becomes important. So probably I have no answers. In fact, the world does not have answer to this as of yet. So in traditional law, I could have answered it, but not in case of artificial intelligence, where probably the person who gives the problem is the owner, the person who finds the solution is the owner, and the technology that solves it, because it's used his own mind, is also
Right.
an owner.
Now, to add to what our student has said, like I use a smartphone application created by some company, and they own that. It's not an open source. They say it is our product. I use the application to create some music. I upload it. I did not ask for any copyright. It becomes popular after 5 years. I see millions of people using it. Can I claim a copyright on it then? Finding it out that now I had released it, and now I want to make money out of it. Maybe I say that now it is used, so why not I put my ownership on it?
Traditionally, yes, you can. For example, I mean, your example is YouTube. YouTube is an app owned by Google. You create your own music on it. You create and you upload on the same YouTube. So who owns the copyright in that, right?
Yes.
So traditionally, I could have answered, you own the copyright. YouTube doesn't, yes, because you could do it in other platforms also.
But still, like these youngsters have got one thing, they'll sing a cover of maybe, like there's a singer, most of us know, Sami Yusuf. So you're singing a song sung by the singer, and you're singing only for maybe 2 minutes of it, singing with one of your friends playing the guitar. The song is actually his song. You're uploading it. Your singing becomes popular. He claims a copyright on you, and he says, this is my song. So you have to delete it, or you can say that, no, I improvised something of it.
No, so then you will be infringing. And now I'm going to the traditional law, okay, because I'm not talking about the new law, but traditionally you cannot do that, because you have taken some tunes from the previous copyright holder and you have modified it. It's something like caller tunes, the caller tunes or the mobile. So if you have a song, say in a caller tune with the different tone or with the different voice, but you're still violating the composition of the music, right? You're still violating. Right. So you a part of that is already copyright, and you are maybe adding your own voice to it. You're adding your own instrument music to it, but your composition of the music, the way it goes, you can easily identify that, oh, this is an old song in the new, and maybe it is only 10 seconds. I'm talking, even if it gives you a hint, it's a 10-second. You are violating the copyright of the person who actually originally composed it, and he can claim it back. He'll say, okay, you do whatever, but don't use my composition. Maybe you've done so many things over that. Okay, this is like the copyright. With patents, my answer would have been different if it wasn't an invention. But yes, copyright, of course. Yeah.
Quite important for this generation, I would say. It is like that we are playing a song to dance in a party, and the owner comes and says, stop playing it, it is my copyright.
Yes.
So can that also happen?
Yes. So all these, I don't know if you people are aware, all the gyms, because they are running a music, all the restaurants, if they are running the music, they have to pay a copyright fees to a music association.
One more question we have.
Yes, we do have one more question from us, sir.
Hello, sir.
Hi.
Thank you for your lection. It was really informative. But I have a question. We've learned a lot about advantages of artificial intelligence, but what about disadvantages? Don't you think that in the future they may replace the humanity, not only the particular people?
Mm-hmm. So if I understand your question, you're asking if the artificial intelligence itself is the creator of IPRs. Is that the question?
Can you simplify your question? Can you tell it again? you are worried about?
Yeah.
Every day.
Don't you think that artificial intelligence,
AI?
new technologies may replace the people at all, humanity?
Okay, they are me. So do you think that AI or all these things coming up, robots and all, they'll replace human beings someday and we'll be like out of the world and they'll be ruling us? No science fiction though.
Yeah,
Like,
I really don't think so. The way we do business, the way we do work will of course be replaced by artificial intelligence. Our behavior will change, our attitudes will change, it will influence us a lot. Definitely, it will replace our jobs also. But to replace completely and to take over humanity is fiction as of now. I don't think so that will happen. But
so we are still the
more and
boss
more
over
jobs
technology.
are being replaced, and including IPRs, I will say, which we are talking about.
Right, sir. They do have their own, I would say, curiosities, because what you were talking relates to a fear as well as a confidence we have on, I would say, human beings, that if there are people who take copyrights, there are people who put it in the open domain as well. So it goes balanced that way.
I agree. This is
Right. So if we say just one small thing on a happy note to conclude, the video or the things that you have spoken here in this conference, it is on our YouTube channel. The students can refer to it and it will be completely a learning right of them.
Thank you. I'm glad I'm able to share my knowledge and experience. Thank you for having me here.
Thank you. Thank you very much, sir. It is time to felicitate you. And we all, on behalf of Amity University and Tashkent, the whole conference team, thank you for sparing your time, providing us insights which are going to be useful in future, are useful in the present as well, and will also correct a few things that we know through the past. Thank you very much, Mr. Dinesh Jotwani ji. We look forward for a long association.
Thank you. Thank you. I also look forward.
Thank you, sir. Thank you very much. Yes, everyone, we are concluding with the keynotes on day 2. The paper presentations will be taking place at the respective